My name is Steve Landis. I'm a lawyer at Lock Ward, and I'm happy to welcome all of you with our panel to talk about a subject that is of increasing concern daily. And it has to do with what they call BDS, boycott, divestment, and sanctions. As recently as last week, there is a situation involving the famous singer Matisyahu. Many of you know who he is. Trust me, your kids know who he is. He's a famous singer who was invited to entertain at a festival in Spain. And that was considered a very big deal because he's very famous and very good. But suddenly, the invitation that he received was canceled because he refused to sign a statement essentially affirming Palestinian rights in Israel. There was a protest. It was publicized. Matisyahu said he was not signing any such statement, and they relented, and he appeared. And he sang his famous song, Jerusalem, amidst the sea of large Palestinian flags. But the question of Matisyahu is really somewhat emblematic of the problem. Matisyahu is not an Israeli citizen. Matisyahu is an American citizen, an American Jew. It leads to the conclusion, obviously, that Matisyahu is being singled out because he's a very public Jew. And had Matisyahu not pushed back, he would have lost income, he would have been deprived of this opportunity because of his failure to express views that coincided with that of the BDS movement. Now, we know the BDS movement from other things as well. We know the basic concept was to boycott goods, professors, intellectuals from Israel. Now, the original notion, as I understand it, had to do with the settlements. For example, we all know that SodaStream, which is a very successful business that has a factory in the territories that, in fact, overwhelmingly employs Palestinians, was being boycotted. We know that agricultural products coming from the territories were boycotted as well, particularly very heavily in Europe. And we now see the BDS movement against all products from Israel and all intellectuals from Israel, no matter where they live in Israel. We see continued threats from the EU to sanction Israel unless it eliminates the closures in Gaza, and these persisted even while the rockets were coming into Israel from Gaza. We already have situations where Israeli banks are being boycotted by financial institutions in Scandinavia. Now, this does not only relate to Israel. We see this here as well. Jewish students on campuses are assaulted, and not just verbally, but physically, because presumptively they're Jews and therefore they don't follow the progressive theory of Palestinian rights. There's a notorious case about a situation at the University of California where a woman was being interviewed for a position in student leadership, and she was disqualified and denied a place in student government because she was Jewish and presumptively would not have the proper views of political issues. The question we really have to face is how deep, how persistent, and how difficult is it, and we're lawyers, to play our role in acting against this BDS movement. Are we facing a situation of, as Kenneth Marcus of the Louis Brandeis Center says, whether under the guise of attacking Israel, we're fighting an entire new wave of anti-Semitism. And we have to ask, even in the dispute between Israel and its neighbors, whether this is a new lawfare type of approach, and to what degree is it even being supported by terrorist organizations and others who would otherwise be disqualified from providing this type of support. So there are any number of issues and any number of approaches that have to be considered, have to be employed, and to deal with the BDS movement, and we are today going to explore a number of these possibilities. There has been recently some important legislative efforts to confront BDS. both on the federal and state level. We will hear from Michael Shapiro, who has for the past 2.5 years been an important staff member for Congressman Roscoe, Peter Roscoe, who was very successful in promoting legislation that would contradict and counteract against the BDS movement on a commercial level. The question of campuses is very severe. I would just say I know Michael Shapiro. I practiced law with his dad for many years. And it's great to see the next generation come up. And our next speaker, Elisa Lewin, who is the president of the American Association of Jewish Lawyers and Jurists, is also someone I've known since she was very little, because I've known her father for a long time, Nathan Lewin. And I tell you, it really is heartwarming to see people just continuing to move up and moving up in support, just as the parents have supported Jewish causes. Elisa has been very involved in the issue of dealing with the situations on campuses. And she'll speak after Mike. And then the question is even broader. The question of when you confront what is apparently under the guise of political speech, in terms of saying, well, we're only interested in Israel's activities politically, and you're confronting an issue that we think has a lot more to do with anti-Semitism than pure political speech. What are the constitutional ramifications? We're very fortunate to have my good friend and colleague Nathan Lewin, who is one of our outstanding constitutional lawyers, will speak on that as well. So we have a very important panel today, and we'll start with Mike.
Thank you, Steve. Thank you, Mayor, and Nathan and Lisa, and my parents and my grandparents who slept out to come witness me read notes that I just wrote down as Steve giving his introduction. So, in all seriousness, so thank you very much. In the spirit of full disclosure, I am not an attorney. I have not gone to law school. I don't currently plan on going to law school, but I am a 25-year-old Jewish kid from Highland Park, and I do know something a little bit about BDS, particularly from my time at Columbia, where I led the pro-Israel group there, and certainly during a lot of the campus protests that I'll let Elisa speak to. But I worked, as Steve mentioned, I worked for Congressman Peter Roscoe. He's a Republican from the western suburbs of Chicago, not a highly Jewish district, but a man who is deeply, deeply committed to the state of Israel. We just got back from 7 days overseas. We were in Poland visiting the concentration camps, and then we were in Israel, where we had a series of meetings. And as you would imagine, the primary focus is on Iran, and I'm happy to speak on Iran until this evening, but a lot of the meetings were actually on BDS, including our meeting with the Prime Minister, who spent the first portion of our time together talking about the threat of the Iran deal as he sees it, and then we went into a discussion about BDS. So my theory is that we can walk into them at the same time. We should address both these issues. They're not mutually exclusive, and we need to address both of these issues. So let me just give you a quick background here, and then I'll answer any questions after our other speakers get a chance to say a few words. The way that I see it is the BDS movement is the third manifestation of efforts to delegitimize and ultimately destroy the state of Israel. So the first wave of efforts to destroy Israel was when the state was created. And first we dealt with conventional military threats. We saw this obviously in the War of Independence, later in the Six-Day War and the Yom Kippur War and so forth. That was followed subsequently by a new form of violence against Israel in the form of terrorism, in the intifadas and suicide bombing in the streets of Jerusalem and Tel Aviv and so forth. Those are the first two waves of, as I see it, efforts to destroy the Jewish state. But those efforts failed, and so anti-Israel activists have turned to a non-violent but yet still insidious form of demonizing the Jewish state, and that's the boycott, divestment, and sanctions movement. And if you think about it, it's a smart move. The Palestinians have not helped their cause through violence. They haven't been able to overtake Israel through conventional military invasions. So what do? Well, they go with a diplomatic route of saying we're going to start a peaceful movement to speak out against Israel's policies. Now this is where I think we have our first objection to the BDS movement, which is we all know that, and the way that this manifests itself, this is not about Israel's policies. This is not about borders. This is not about settlements. This is not about Benjamin Netanyahu or anything else. This is purely about the existence of the Jewish state. But it's a smart move, and they've been relatively successful in many ways. But I'm here to tell you that we're actually doing a good job pushing back. And here's how. You know, in the 40s, 50s, and 60s, after Israel was founded, there was a coordinated effort, as many of you know, called the Arab League boycott, and a coalition of Arab states made a concerted effort to boycott the state of Israel. The United States, in the 1970s, the late 1970s, under President Carter, of all people, enacted legislation in 1976 and 1979, respectively, to effectively prevent U.S. companies from participating in the Arab League boycott of Israel. Within about 3 years, this was successful. You don't see, for the most part, U.S. companies openly participating in the Arab League boycott of Israel. This was a major success, and this was the first time that the United States government took formal action against efforts to boycott Israel. But today the movement is different. It's evolved, it's smarter, it's more coordinated, it's better funded, and I think it manifests itself in three parts. There's an academic portion, which we'll discuss. There's a cultural portion, Netanyahu not being able to, or almost not being able to perform in Spain. And then there's an economic component. And the way I see it, all three are equally dangerous. All three pose threats to Israel's credibility and legitimacy. But you know, we've noticed in the past few years, I have, the congressman has, people far smarter than you have, and I pointed it out to our office, that a lot of the economic activity in particular is coming from the European Union. And why is that interesting? It's interesting to me, at least, because many of these countries are our partners. Many of these countries are our closest partners in the world, including the United Kingdom and Netherlands and so forth. So we've seen a litany of financial institutions decide to divest from Israeli banks. We've seen the UK Trade and Investment Agency in 2013 issue a report, a risk report, to UK companies saying, do not do business with companies in Israel. You may be dragged into lawsuits over Israel's settlement policy. A couple of years ago, in 2014, there was a leaked document from all representatives, all EU member state representatives, threatening to sanction Israel if they're not going to change their policy vis-a-vis settlements. These are just a couple of the activities we've seen, and again, from allies of the United States. So we sat down and we tried to figure out how do we address this one component of BDS. It wasn't going to be a comprehensive approach to the BDS movement at large. I mean, if you hear in Washington someone say they have a comprehensive solution to something, you probably know there's something wrong with that. But our approach was we should fight economic warfare with the weight of the U.S. economy, and that's what we set out to do. So we tried to look at it, and this was about 2 years ago, and sit down and say, how do we leverage that weight of the U.S. economy with our foreign partners? We can't just boycott those countries or those companies that participate in boycott straight out. So we set out to amend a bill called Trade Promotion Authority, the trade bill that was recently debated in Washington, very controversial. And you can support it or you cannot support it. That's perfectly fine. But the reality is this bill was moving. And what the bill does is it lays out 150 negotiating objectives for the United States trade negotiators. That says, you know, we need to do this with regards to tariffs and this with regard to imports of sugar and so forth. And these are a very rigid set of negotiating objectives that our negotiators are required by congressional mandate to pursue in their negotiations with other countries. And as many of you know, this is actually authorizing the negotiations with the European Union. We're currently negotiating what's called the Transatlantic Trade and Investment Partnership, TTIP, with the European Union. It will take somewhere in the next few years to several years, depending on who you ask in Washington. But this will be the largest free trade agreement in U.S. history. And we recognize that we have an opportunity to add a negotiating objective. A negotiating objective that would essentially stipulate that our free trade partners, in this case, those European countries, cannot participate in boycotts against Israel. And I can go through in specifics what the legislation does, but in in the interest of time and not boring you all over lunch, I will simplify it and say if you want to do business with the United States, you can't boycott Israel. That's what we set out to do. And after about a year and a half worth of back and forth with the administration, with the relevant committees in the House and the Senate, we were able to unanimously amend the trade bill using a bipartisan coalition of members in the House and the Senate that my boss helped lead to make this negotiated objective a reality. And this was signed into law by the President in March. And we've already had discussions with our trade negotiators. They've already raised this as something they're going to need to discuss over the next several years with the European Union. And here's what the end goal is with this. And then I'll close up because I know we have other folks that have some interesting insights as well. The end goal here is we want these countries to not boycott Israel. And how do we ensure we accomplish that? By rigorous oversight, by making sure that every time there's an Orange or Orange, the French telecom company that's partially owned by the French government, every time one of these pops up, it is our negotiator's job to go to the French government in that case and say, here's a company that you guys have a partial ownership stake in. We need you to ensure that this boycott doesn't happen. They will be mandated under the trade agreement to not participate in that activity. We actually saw this work in a different style with free trade agreements with Bahrain and Oman in the mid-2000s. The difference with those is that these BDS, these anti-boycott provisions, were negotiated on the side of the talks, and there's nothing formally binding there. So what we did is we made these central to the talks and legally binding, congressionally mandated. So we've seen this work before. We're hopeful and confident this is going to work moving forward. And the last thing I'll add is that we do have a good opportunity here to build on this. Like I said, this doesn't solve BDS. This is not going to protect students on campus. It's not going to protect Nazi Scotland from performing. But we've already seen congressional hearings on BDS, which we had never seen before. We've already seen several states, including Illinois, take action at in a legislative manner against BDS. And we've actually seen groups like AIPAC, which have never really gotten themselves involved in BDS as we know it. We've seen AIPAC and other pro-Israel groups get involved in this effort. So I really think that we have an opportunity to build here. There are other legislative ways to address this. We're going to continue to pursue those. I'm happy to answer any questions, but I'll yield to my colleagues. Thank you.
I think one point is here in Illinois, legislation that was passed that, there's been these efforts to have companies that invest in Israel not be part of pension plans, and that we have legislation that was passed in Illinois that simply says, okay, you invest yourself in Israel, we're not going to invest in you. I think that's a very important step that was developed in our legislature, signed by the governor. And I will move on to Lisa, will talk about what's going on in campus.
Thank you, Steve. Thank you, all of you, for joining this session today. Michael and Congressman Roscom should be commended. The state of Illinois, all of these steps are very important, but we still have a long way to go, and there is a lot that I think can be done and should be done. As of the end of May, now 2015, to the end of the academic year, there were at least 29 university campuses, including Northwestern, where student organizations had introduced boycott, divestment, and sanction resolutions for a vote on their student campuses. And one of the things that we have seen is that as these campuses, as these resolutions have been introduced, and as we've ended up with the BDS campaigns on campuses, there has been a slip into anti-Semitism on those campuses. So oftentimes you'll start to see around the same time as the BDS campaigns, swastikas. There were swastikas that appeared on the Northwestern campus, or graffiti or language that's clearly anti-Semitic. At UC Berkeley, there was a scrawled on a bathroom wall with the statement, "Zionists should be sent to the gas chamber," or at UC Davis, there was a Hillel House that ended up with "Rout out the Jews" written on. So we start to see there becomes a climate on campus that shifts into where the anti-Semitic language almost seems acceptable, because the BDS language, which can border on anti-Semitism, and we'll get to this in a minute, is not challenged as anti-Semitic language. And so the climate becomes one where anti-Semitism appears to be acceptable. The real question is, how do we distinguish between the pure political advocacy and these anti-Semitic statements? The State Department, believe it or not, has a definition of anti-Semitism that is quite useful. What's ironic about the State Department's definition is that it's been applied by the State Department and used abroad, but never been recognized as a definition to use within the United States. The State Department definition of anti-Semitism, the definition itself, and it's in the materials I think that are posted as part of the materials and handouts for this whole program, says that anti-Semitism is a certain perception of Jews which may be expressed as hatred toward Jews. Rhetorical and physical manifestations of anti-Semitism are directed toward Jewish or non-Jewish individuals and or their property, toward Jewish community institutions and religious facilities. It's not so much the definition that has been really important, but the examples that the State Department has given as to what constitutes anti-Semitic speech. And the definition and the examples that are given specifically talk about what is anti-Semitism relative to Israel. Because what's happened on the campuses is that the pro-BDS proponents recognize that if they throw Israel into the mix, then almost automatically what they say appears to be protected speech. And the question is, when does that speech perhaps cross the line? And so the State Department created or set out what they have become known as the 3 Ds, the letter D, as 3 examples of speech that can cross the line when it relates to Israel and be considered anti-Semitic speech. Those 3 Ds are delegitimization. In other words, speech that denies Israel's right to exist or denies the Jewish people's right to self-determination. That would be considered anti-Semitic. The second D is demonization. When you use symbols or images that are associated with classic anti-Semitism, like swastikas or Nazism, to characterize the current state of Israel or Israelis, that is anti-Semitic. And the last D is double standards. Holding Israel to standards that are not demanded of any other country is anti-Semitic. So this would include focusing on Israel, for example, for human rights violations or civilian casualties in an armed conflict where no other country is held to those standards. That is anti-Semitic. And the State Department definition specifically sets out those 3 Ds and notes at the bottom that criticism of Israel that's similar to criticism that would be leveled against any other country, that's not anti-Semitic. But if you veer into delegitimization, demonization, or double standards, that could be considered anti-Semitic. The Student Senate at UCLA, at UC Berkeley, and at UC Santa Barbara all unanimously approved resolutions that condemned anti-Semitism that were based on this State Department definition. And in fact, a few months ago, the California State Legislature even unanimously passed a resolution that used the State Department's definition and that urged each University of California campus to adopt resolutions condemning all forms of anti-Semitism. In June, the president of the UC, of University of California, promised, that's Janet Napolitano, she had promised that in July, the UC regents would actually vote on whether or not to adopt this State Department definition as the definition of anti-Semitism. Well, at that point, when the momentum had started to grow, that's when the pro-BDS forces began to mobilize in opposition to this definition. And they started to put tremendous pressure on the UC regents and on the State Department, too, to alter this definition. They started to push and claim that these 3 Ds, if applied, will restrict free speech and will limit protected speech. And therefore, this definition is much too vague and should not be used or adopted. The result was that at the July meeting of the UC Regents, the issue was totally taken off the agenda, wasn't mentioned at all. And now what has been announced is that in September, at their meeting, the UC Regents, instead of discussing a definition of anti-Semitism specifically and whether or not this definition should be adopted, the UC Regents are going to discuss a statement of principles against intolerance, including but not limited to anti-Semitism and other types of intolerance. So we'll be talking about tolerance. It's always a nice thing. But the question will be, how will the university define anti-Semitism? Now, the group Jewish Voice for Peace, JVP, which is a misnomer if there ever was one, most of the group are not Jews, and it's questionable as to whether or not they are for peace, but they are certainly for BDS. They have lobbied very hard and lobbied the State Department. They sent a letter that was signed by more than 250 academics and a petition that was signed by over 15,800 people to the State Department. They said pushing the State Department to abandon this definition. And Ira Foreman, who is the special envoy of the State Department who deals with anti-Semitism, responded. His JVP has not publicized that letter, but the little bits that were apparently leaked to the press suggest that he made clear that the definition has never been intended to restrict free speech, and that the definition has proven useful in his efforts abroad in terms of identifying anti-Semitism. So the question now will be, what will universities or even the Department of Education do here in the United States? Will they recognize that some speech, as it connects to Israel, does cross the line into anti-Semitism? The ADL sent a letter to the regents endorsing the definition, but stating that while it's important to define and recognize anti-Semitism, they should not use this to limit or restrict free speech. In other words, you have to determine how the definition will be used. And Tammy Ross Benjamin, who's the founder of AMCHA, which is an organization that's been very active and involved in trying to combat BDS efforts on campus, she, in a recent letter, also said, defining anti-Semitism simply allows for its identification. It does not prescribe shutting down free speech or taking any other disciplinary measures. The point is that if you at least identify anti-Semitism as anti-Semitism, it may not be against the law, but it is certainly bigotry, and it ought to be recognized and condemned and challenged and shut down with the same forcefulness, with the same passion that we try and shut down or combat or respond to any other forms of racial, ethnic, or gender bigotry. And it should be recognized for what it is. What has happened on these campuses is that these pro-BDS efforts that have then slipped into anti-Semitism have created climates on campus where Jews have at times felt unsafe. There were polls that were done in response to surveys. Some of the students have talked about the fear and discomfort they have felt. So a quote from a recent UC Santa Barbara student said, quote, "For the first time in my life, I felt that my identity, an unchangeable part of who I am, was under attack. I don't wear that Star of David necklace anymore. I don't tell most people that I'm Jewish, and I definitely don't tell them I'm pro-Israel. I'm scared for my safety. Or another student who was at UCLA said, quote, people say that being anti-Israel is not the same as being anti-Semitic. The problem is the anti-Israel culture in which we are singling out only the Jewish state creates an environment where it is okay to single out Jewish students. And that's what Steve had mentioned at the beginning too, where Jewish students are reporting being attacked or singled out for defending Israel merely because they are Jewish. And that automatically they are identified, therefore, as being pro-Israel. And they're on the receiving end of some very hostile comments or behavior. There is, and I should mention just briefly, Title VI of the Civil Rights Act of 1964. That's a federal law that prohibits discrimination on the basis of race, national origin, or color in programs that receive federal funding. So almost every private or public university would be subject to this. The one catch is, if you listen carefully, it doesn't specify religion in that group. But in 2004, and again in 2010, and this is due in large part to the efforts of Ken Marcus when he had been at the Civil Rights Division in the Department of Justice, they extended the definition of Title VI so that it should protect students who were discriminated against based on their actual or perceived ancestry and ethnic identity as Jews, so that it gave some Jewish students protection under the law against discrimination on the university campuses. In order to get that protection, though, and to bring a Title VI claim, the anti-Semitic harassment has to create what is called a hostile learning environment. And for that to be, the offensive conduct has to be so severe, persistent, or pervasive that it interferes with or limits a student's ability to participate in or benefit from school programs or opportunities. It ends up being a fairly high level that they have to reach, but there have been a couple of successful Title VI measures brought, and it is something that now students are being encouraged to, if they feel that there is a hostile environment on campus being created, that they should record it, they should take notes, they should video or photograph or screenshot if there are things that are appearing on social media, so that these kinds of cases could be brought when necessary to try and protect the students' rights. Just in closing, I think that there need to be additional tools. And as Michael had said, and Steve knows well, because Steve worked with us when we brought an anti-terrorism suit. We brought a lawsuit on behalf of a victim of terror against the Holy Land Foundation for Relief and Development and others who were supporting Hamas. And we know Steve Perlis is in the audience here. He too has done just this kind of litigation. And one of the beautiful things about the Anti-Terrorism Act is that it created a private cause of action for those who were harmed by acts of international terror. I think that as we think about legislation, it would be useful now when you talk about the different waves, Michael, of the efforts to destroy the state of Israel, and you talk about terrorism being kind of the second wave and this being the third. I think we need similar tools. I think we need legislation that will create a private cause of action for those Americans who suffer financial harm or suffer damages as a result of the boycott, divestment, and sanctions movement, to be able to bring litigation, to bring a lawsuit against those who are pushing for that boycott. So for example, if you go on to the BDS website, their formal website, you will see that they are now calling for a boycott of Ben & Jerry's. Ben & Jerry's is not an Israeli company. Ben & Jerry's is an American company up in Vermont. Why are they pushing for a boycott of Ben & Jerry's? Not because Ben & Jerry's makes their ice cream, some of their ice cream at a plant in Israel proper, and they note that it's manufactured at a plant in Israel proper, but they have the audacity to sell their ice cream in Judea and Samaria, or in the area across the Green Line of the 67 borders. So they claim on their website, we have tried over the years to convince Ben & Jerry's to stop selling their ice cream there in Israel, and they've refused. We tried to get them to sign a statement, just like they tried to get Matisyahu to sign a statement in support of the Palestinian cause, and Ben & Jerry's have refused. So it is time, they said, for a boycott. For a boycott. Why shouldn't Ben & Jerry's have the legal option, if they suffer financially as a result of this boycott, to sue those who are pushing for the boycott of Ben & Jerry's? On the website, it also says that they pushed for a boycott of New Balance and Crown Plaza. Why? Because New Balance and Crown Plaza were sponsors of the Jerusalem Marathon. You know, if New Balance and Crown Plaza suffer financial damages, why shouldn't they have the opportunity to bring a lawsuit? So I throw that idea out there for discussion as one tool that maybe we can consider creating.
Well, Steve, in his very generous introduction, did not mention that I am now a partner with a firm called Lewin and Lewin. Now you can see why I'm rather proud of being a partner in Lewin and Lewin. And people say to me, Lewin, which Lewin are you? I say, well, before I can even answer, the people who are smart say to me, Lewin, with your old firm, when you weren't with your daughter, but for many years with a firm where all the other named partners were not Jewish, it was Miller, Cassidy, LaRocca, and Lewin. So you must still be and Lewin. That's fine. So I'm second. But people also have said to me, Miller, Cassidy, LaRocca, and Lewin. Lewin, you argued cases in the Supreme Court. You've taught at leading law schools. Why did they make you the last name in that law firm? And I would respond, you don't understand. Most of my clients read from right to left. Anyway, so first Lewin and Lewin and Lewin has given me the perfect segue into what really I'm up here to talk about, which is the constitutionality of a law that would parallel the law that we have used and that Steve Perlis has used, and that now you read about the Arab Bank case and all that. We brought, and Alisa gets a lot of credit for it because she came with that old law firm I was with and really pushed for us to bring the Boyne case, which was a case of a young boy who was killed by Hamas terrorists while he was standing at a bus stop in Bethel. And we brought that lawsuit, and thank goodness Steve Landis here in Chicago joined a law firm that was ready to undertake the trial of that case after we fought in the courts of appeals and finally went up to the Seventh Circuit and got an in-bank decision from Judge Posner that affirmed a judgment which I wish we could collect. The judgment was for $156 million against the Holy Land Foundation. The problem was the Holy Land Foundation, by the time we sued them, and by the time money was left, it had almost nothing left, almost nothing. So, you know, it was a successful lawsuit. It was one that got a lot of play in the lawyers' newspapers. I think that week we had or maybe that month, the top jury verdict in the country, $156 million. But what did we do? We sued because there was a statute that said that if an American national is harmed by an act of international terrorism, you can sue in a U.S. district court for damages. And the question is, why shouldn't there be a similar parallel statute that says that if an American national is harmed by a boycott against Israel, then he can sue in an American court for damages? Now, the constitutional scholars
would immediately raise a number of objections. And I'm up here to talk about those objections, because I don't think they would withstand a case that would be brought under such a statute. The first challenge would be, look, all these people who are engaged in boycott activity are just engaged in a First Amendment protected activity. It's all speech, that's all that's involved. Well, if that's what they say, they don't know what the Supreme Court law is, because the Supreme Court has clearly distinguished between speech which conveys ideas, political ideas, and speech which is commercial speech. How does the Supreme Court define commercial speech? In the leading case, which has been quoted since then, this was an opinion by Justice Scalia in 1989, he said that any speech that proposes a commercial transaction, that's what defines commercial speech. Now, what is a boycott if not a commercial transaction? When Matisyahu is prevented from singing, he's prevented, presumably, what they're trying to do is they're trying to hit him in the pocketbook and say, you're not going to get paid for being there. When SodaStream is challenged, when Ben & Jerry, after all, Ben & Jerry is as leftist a group as you can get in terms of Israeli policies, and yet they're trying to hit Ben & Jerry. When Ben & Jerry is hit, that's commercial damage. Commercial damage, speech that affects and has an impact in terms of any commercial transaction, is not protected by this First Amendment the way pure speech, political speech is. The Supreme Court has made that clear. The commercial speech is subjected to what the constitutional professors and lawyers call intermediate scrutiny. It's not the strict scrutiny of pure political speech, but it gives a lot of weight to legislative determinations as to what is appropriate and what is where the line should be drawn when you're saying you can't engage in speech that's going to harm somebody else commercially. Now, that's not so unusual, after all, in the constitutional context. We all know that even what appears to be pure speech can be a subject of lawsuit if it's defamation, if it's false representation, if it's in some way causes economic harm to the party that is the object of your speech. And the same thing is true if Congress were to pass a law that would say if you engage or you encourage a boycott and an American national suffers economic consequences, that American national can bring a lawsuit in a U.S. district abroad. American national living abroad or American national with regard to business abroad can bring a lawsuit, can recover, as the statute that we use in the Boehm case provided, treble damages and attorney's fees, and it can be brought in a U.S. district court. Now, what is the other problem that comes up? The other problem that comes up is, how do you distinguish between boycotts? People would say, historically, after all, there was a boycott against South Africa. There was a boycott in the 1930s against Nazi Germany, German goods. And I say to you that it seems to me that just as Congress can make economic judgments with regard to foreign countries, which distinguish for tariff purposes, for other purposes, between one country and another country, Congress can make economic judgments that say we want to encourage commerce in Israel. And in fact, I would submit to you, although I'm not saying Congress will overwhelmingly adopt this, but Israel and Judea and Samaria. Now, the U.S. government, of course, is not going to support that broad a statute, but nonetheless, a statute that says that in the interest of encouraging the growth of commerce in Israel, we say specifically that any American national who is harmed by a boycott or by some effort to harm him economically because he is in Israel, he has an interest in a business in Israel, can sue in a United States District Court for damages. I submit to you that's a statute that Congress should adopt, and if people want to test it in court, but if Congress adopts it and you find individual American nationals who are harmed by BDS and they can bring a lawsuit under that statute, my prediction is that that lawsuit will succeed, just as the lawsuits have succeeded in terms of suing those who committed violent acts that constitute international terrorism. Thank you.
We have a little time for some questions. I'm sure there are questions, so let's go. Go ahead. Thank you.
I wonder what the J Street University are doing with respect to the anti-BDS program. Are they active in fighting BDS?
Let's see if the J Street, the question was whether J Street and the J Street Union, the student group, are active in combating BDS. So we had the spokesperson for J Street participate in a conference on BDS that I ran at the University of Baltimore in April. And he was asked about that. And the answer that he gave is that they chose to leave it up to the individual chapters to decide what they wanted to do. But he said that they oftentimes felt that their students were perhaps in the best position to deal with the pro-BDS folks in terms of discussions with them, because they weren't automatically opposed to everything that the pro-BDS folks stood for. Just shortly before that session, there had been a BDS resolution introduced at Princeton University. And the initial response of the J Street student group at Princeton was to say, we're not getting involved in this at all. That was kind of a message they posted on their Facebook page. So he said, this is the spokesperson, Alan Elsner, said that they were not pleased with that, so they actually spoke to the student representative and got them to change their position. But what they got them to change the position to was a statement saying that J Street U is taking no position on the BDS resolution. So from what I have seen, the J Street students are not in any way, shape, or form actively fighting against the BDS efforts on campus.
Rod?
How
Stand up.
How would you describe the people, as opposed to just saying that they're anti-Semitic? How would you describe the people who support the BDS movement? My impression is, just an impression, is that they are very much politically to the left, and that it stems from their view of the Palestinians as an oppressive people, and that they are helping to support what they view as an oppressive people. Why couldn't, for example, see something like Milton Friedman, supporting
Yes, maybe respond in terms of what you saw in the Congress's office when you did this, and talk about any of the political pushback you may have gotten.
I think there are a couple of things. I mean, we saw with our legislation J Street actually actively opposed legislation. They were publicly opposed to it. They were opposed to it behind closed doors and stuff. And so we dealt with that by simply ignoring them and reminding them that this was legislation that was unanimously adopted in the House and the Senate. And the House and the Senate, as many of you know, can't agree on the time of day. They can't unanimously vote for adjournment for recess. So, look, I mean, the way we see it is we knew that we were affecting policy. I think you make an interesting point, though. There's a book that came out a few years ago called Underdogma. And it's written by, I forget the author's name, a neoconservative guy, and he tries to understand the technology behind why people support underdogs in all cases. So they take teams that are playing the Yankees, and people root for that team, and people in this city seem to root for the Cubs, which I still don't understand, and so forth. So they go through a litany of examples, and I was raised a White Sox fan. Roscoe's a Cubs fan. But he does get into an example about Israel and Palestine. He makes an interesting point, and he said, look, before 1948, Israel was the underdog. The Jewish people were the underdog, right? We didn't have a state. And after 1948, we had a state. And over the next 65 or so years, it became a successful state and a flourishing state. And in that process, the Palestinians became the victims, the underdogs. And he cites a study that's pretty interesting where focus groups were put in two separate groups. One group looked at a map of Israel that was zoomed in. You all know what it looks like, and you see the Gaza Strip and the West Bank, and then this big country, Israel, right? You've seen those maps, and you've seen the ones where they show over years how the Palestinian territory has become smaller and so forth. And they asked that focus group, who do you support? Who is the oppressed versus the oppressor in this scenario? Naturally, a majority, if not all of them, say the Palestinians. The other focus group looks at a study with Israel and a zoomed-out map with Jordan and Egypt and Syria and Lebanon and Iran and Iraq. And they say, who's the oppressed and who's the oppressor in this scenario? And I think you know how people respond. So I think you need to put these things in context. I do think there's a victimization on the part of the Palestinians. I think they've done that successfully. And that's not to say that we're here to discredit all claims that Palestinians make. But in terms of how BDS manifests itself, we believe that this is an anti-Semitic movement under the guise of legitimate boycotts to prompt policy changes. So that's the way I've seen it in my experience.
Lisa, do you want to comment?
I just think you have to distinguish also between those who are the creators or those who established the BDS movement and those who are following or listening to what they're hearing and the rhetoric that they're hearing on campuses and elsewhere. Those who have established the BDS movement they're not looking to change Israel's policy. I mean, they oppose the occupation of the West Bank. They demand the right of return for all Palestinian refugees. Now, that's a topic for another whole lecture, but to demand the right of return and insist on it for the inflated number of Palestinian refugees into Israel proper, not into any Palestinian created entity, and then to also demand equal treatment for any Arab residents in Israel proper, essentially means not two-state solution, it means two Palestinian states that take up the entire area of Israel. And that's their goal. And they are very, very clever in having appeal to the liberal instincts of a young population on campuses and others. You're right, with this whole underdog mentality. But those who founded it and those who created it, make no mistake about it, they're not looking to change Israel's policy. That's not why they're pushing for boycott. They're pushing for boycott to try and bring down the state of Israel. That's a very interesting question that there have been people who have been... Yeah, the question is, what is the source of funding for the BDS movement? There's a group on campus, the Students Justice for Palestine, and it's a very interesting question that there have been groups, and I know researchers who've been looking into as to who is funding that group, because that group has jumped in terms of its influence and activities over these past several years at kind of record speed. And I don't yet have the definitive answer to that.
I think it's fair to say there's a lot of really serious work being done. I think that nobody's reached a definite conclusion. We've been working on it, but my guess is that you wouldn't be surprised to think that that is just part of the same, as I said before, the lawfare and warfare with groups and that we faced years before that support radical Palestinian causes. I wouldn't be shocked if some of them weren't engaged in this as well. Some of the same people, but I can't say who, and I don't know who. Go ahead, sir.
I'm a little unclear on this. Someone says, don't buy gallon shoes or ice cream or something, because the money you give them will go to support Israel on the political dispute between Israel and the Palestinians. And I think you should support the Palestinians, not the Israelis. So please don't buy those shoes. Is that a statement of free speech or an improper, bigoted boycott?
That individual statement, just as an individual statement, would not qualify, I think, as a boycott. In other words, I think the statute has to define boycott as being an organized effort of some kind, not one individual statement. Look, I don't like Israel, I like the Palestinians. But we're talking about an organizational effort to engage in a commercial harm to a particular American business or somebody in which an American has a substantial financial interest. We recognize, for example, in various other areas of the law, the antitrust laws. I mean, you need a substantial entity to be violating an antitrust law. You need a company that has some kind of economic power. We're not talking about just an individual statement of opinion. I agree with you. An individual statement of opinion that says, don't buy Ben & Jerry's ice cream because Ben & Jerry's sells in Israel. No, that's not. I don't suggest that Congress enact a law that does that. On the other hand, Congress can define in the law what is a boycott, which is an organized effort to bring down or to harm economically some enterprise because it does business in Israel. So it's a question of statutory definition.
And I think we faced that actually in Boeing. I mean, we talked about the money that was being raised by Holy Land Foundation. We weren't suing the people in the mosque to put the money in the pushka, I mean, right. that wasn't, I think, constitutionally under the law, we couldn't do that. But for the person who said, all right, I'm going to take all the money in the pushka, I'm going to use it, and to support an infrastructure that to train suicide bombers, that's the people we went after. And I think that's an analogy that we can
right. I mean, I think there are analogies with the physical harm statute, 18 U.S.C. 2333, which we used in the Boeing case. Yes, sir. Yes. Please.
So I'm referring to Northwestern Superintendent of a lot of issues that this borderline anti-Semitism, anti-Semitism. So a lot of this seems to be coming online on social media.
Could you speak up so we can hear in the back too?
Sorry, I've seen a lot of anti-Zionist rhetoric discussed online on social media from other schools. And they call, for example, I've seen examples where they call Zionists dogs, scum, etc. So is there anything I can do in terms of the university to get them to act on some of these statements that are online? Is there a possibility of addressing it?
So one question, and I have not looked at Northwestern's policy, but often there are policies that the universities have that govern the kind of climate, the kinds of statements that can be made. You do want to make sure that they are following through if there is hate speech or these kinds of, if it crosses the line to anti-Semitism, you should be able to bring it to their attention. There is actually a wonderful new handbook, which I afterwards come up and I'll email it to you, that just now, about 2 days ago, a combination of groups, Stand With Us, the Lawfare Project, the Brandeis Center, the Zionist Organization of America, and the American Center for Law and Justice all put together a handbook for university students outlining what their rights are and recommending steps, and also giving you a phone number if it gets to the point where you would like to have the assistance of counsel. They'll pair you up with counsel. So come up to me afterwards, and I can send that to you. You'll
All the way in the back.
Please, would you please tell them about the efforts of the American Association of Jewish Lawyers and Jurists?
So the American Association of Jewish Lawyers and Jurists has, as I said, we have run conferences on BDS. We have worked together with these groups and are also in the process of putting together groups of volunteer lawyers who would be willing to help and assist pro bono these students on campus who need the kind of legal assistance. And if you're more interested in the AAJLJ, I have membership brochures that I'm happy to hand out as well.
All right, we have one more question all the way to the back. That's it, okay.
Hi, Steve Post, thank you. You know, I got off the airplane this morning really pumped up and excited because I was going to see my old friend Elisa Lewin. Now I've listened to my old friend Elisa Lewin and I am terribly depressed.
No.
You can talk louder.
Sure.
You have a hard of hearing judge.
Which one? You know, I was saying I got off the airplane this morning very pumped up because I was going to see my old friend Elisa Lewin, who I think we met doing planning and zoning work for the Auschwitz concentration camp issues. And now that I've met you again, you know, seen you again, and listened to all of this, I am terribly depressed. You know, it's a real problem. I have a question about the impact of the movement on individual students on university campuses. There are organizations at the other end of the spectrum from J Street, like ZOA, which sponsor lectures by professionals that Jewish students might be interested in. Does that help in terms of the cushion the impact of this on individual campus students if people in our community, established professionals, go in and give lectures? I'm not so interested in the commercial side as I am on the impact on individual student side. And I think, you know, like you, I've got kids the right age, and we think about this stuff.
No, I would think, and you can ask the students, I would think that any kind of support, lectures, programs, the feeling to be able to enable the students who are pro-Israel on campus to feel that they're not in this alone. I have wanted to also create groups of law students with the AAJLJ who can be there to assist, because we have found that on the pro-BDS side, they have law students or others who are able to help them maneuver the whole, just the procedure of how do you bring and introduce resolutions. And on the pro-Israel side, you have Hill directors who may not have any clue when they go to read the university constitution. How do you go about responding to these, even just as a procedural measure? And so I think that, yes, to be able to create the programs, the support network, the support system is crucial and very important for the Jewish students.
You know, and if you're in Chicago, our federation is deeply engaged in this, preparing students, sending them out, training them, providing supports to Hillel. And I think, you know, it's important for federations to have the access and have the resources. Chicago is an example, I think, of a lot of very effective work can be done. But our time is up, and you can hear Nat and Elisa later. They're going to talk about other cases, and thank you.